Okay, good morning, everyone. I'd like to call a meeting to order for the Land Division Committee hearing of April 8th, I think, not 18th, 2025. At least that shows I'm still awake. Thanks for checking that out for us, Cindy. Just a couple of minor little announcements. If you have any electronic devices that might make a noise when you receive a text or something, please put it on mute for us so we won't interrupt our hearing. When you do want to make a presentation, we'll swear you in and you'll need to come up and use the microphones up front because the meeting is being live streamed. When you do that, please state your name and we'll get you sworn in. Are there any disclosures of pecuniary interest? I have none, either the members? None? Okay. So I have a motion that the minutes of the Land Division Committee meeting held March 18th, 2025 be approved as circulated. Any questions or discussions? All in favor? Motion is carried. The next motion is moved by Doug James, second by Stephen Lewis, that the agenda be adopted as presented. Any discussions? All in favor? That too is carried. Okay, Cindy, I think we'll move on to our first application.
Okay, thank you, Mr. Chair. So our first set of applications are in the Township of Montague, and it's for 3 new lots with frontage on Roger Stevens Drive, which is a county road, and corner of Fletcher Road, which is a municipal road. The 3 lots are just over 1 hectare in size. 2 of them will have shared frontage on Roger Stevens, and the one on the corner will have the frontage and access on Fletcher Road. These applications were supported by an environmental impact study, and that's attached to the application. One of the conditions of consent requested by the township was also an archaeological assessment due to the location of, I think, within 200 meters of wetland and provincially significant wetland. So that has been added in as a consent at the township's request. There is some areas of mapping that show some organic soils just at the north end of the severed lots. Those should be able to be avoided during the development. However, if there is organic soils that impact, they will need to do some additional review, and that's contemplated in the development agreement conditions as well. Other than that, there was some concerns on this one with the neighbor next door due to drainage. Water drainage does pool on his yard, so he did raise concerns, which is why the report or the applications are coming to Land Division. When we looked at the topographical map and the flow of the drainage during, we had the benefit of a fairly wet season this year to look at the drainage. Didn't seem that the severed lots would impact the drainage onto the neighbor's property. The drainage comes sort of more from the north and west. So we didn't feel that it was a situation that would require any sort of additional review. So other than that, those were the main concerns with that application. So we are recommending approval of the 3 applications subject to the conditions set out in the planning report. And there's different conditions for the first lot due to the fact that it will have frontage on the township road. The second 2 lots have slightly different conditions due to the fact that they'll have the shared access onto the county road.
Thank you, Cindy. And who all do we have here that wishes to speak to us in relation to this application? I think, Sean, are you present? Would you like to speak to us through this application? Just a sec, please. Is there anybody else joining on Zoom on this one that you know of, Christy?
If there is anyone on the Zoom that we can't identify everyone due to the names, so if there is anyone who wishes to speak, if you can let us know, please.
Yeah, Dylan McCleary speaking. I'd like to say a few words.
Okay, so what I'm going to do, I'm going to ask you both to affirm. So do you solemnly affirm that the evidence to be given by you in these proceedings shall be the truth, the whole truth, and nothing but the truth? Sean?
I affirm.
Thank you. And Dylan?
I do. I affirm.
Thank you. So we've all been through the reports that were presented, read the information that we were presented. This is the opportunity for people to give us information that we may not have available to us. So Sean, I'm going to start with you and let you provide any additional information that you desire at this point in time.
In terms of the drainage matter, I think the staff report that was submitted captures the essence of the issue. I think I don't think the proposed development will have a material impact on the flow of water to the area in question. So, I mean, I think they articulated the matter very well. And I had one further question about the requirement for an archaeological survey. That's something that I was not entirely familiar with, and I was encouraged by the person who did the environmental assessment just to ask about that particular requirement and if there's any opportunity to have judgment on those types of things.
Okay. Thanks, Sean. Any questions from the committee at this point? Stephen?
No questions on the application, but I would, I got on the conditions and like to hear from the drainage chap there.
Yeah, we'll hear from him next. I just thought if there's any direct questions for Sean, we could do that now on the application. We'll do the conditions later. Doug, anything?
Again, I'd just like to hear from Mr. McCleary on the drainage issue.
Okay, Mr. McCleary, you're up. What would you, what information could you provide us?
Morning, Chair. I would first like to thank Cindy for answering all my questions. My hope in all of this was at the very least to enter a cost sharing agreement with such number company to not only deal with the current water drainage situation, but any future increased volume. My attempt at a personal level was a dead end. At my place of work, I deal a lot with commercial and multi-residential development. In this, we go to great lengths to ensure surface water drainage does not impact neighboring properties. In closing, I respect this committee's decision to move forward, but I disagree with its conclusion. I base my position on real-world experience and having an intimate understanding on how this area sheds water. Though I know this does not stand up on paper. Thank you, Chair, for at least hearing my concerns, though they have gone unsatisfied. Thank you.
Is there Mr. Cleary, is there a readily identifiable solution to the drainage issue that you know of? You're asking to see if there could contribute or have some kind of an agreement to share in the cost of doing it. Is there something that can be done to solve the problem that's I guess affordable and easily doable? I'd like your opinion on that.
Why could there not be some sort of subsurface, drainage tile to go to the ditch at Roger Stevens instead of using my property as, an outlet for their entire property? I have to deal with that flow every spring, and it risks washing my driveway out, which I've put culverts in, but probably should have more.
Okay, thank you. Any questions from the committee members? Stephen?
You're just trying to figure out on the map, where is your property, Mr. McCleary?
I'm not sure exactly, north, south, I guess to the west, basically the
Okay, the big,
rectangle, just to the, I guess, is that the west?
yeah, the big parcel next door. Gotcha.
Yeah, it's 45 acres.
Okay, thank you.
Doug, any questions?
Mr. McCleary, you've read our staff report, and they really are the independent members as far as this investigation is concerned in the drainage issue. And they have come to the conclusion that nothing will change development on either one of these three lots, or any one of these three lots, that none of that will change as far as any development on these three lots. But you disagree with that, do you?
Yes, I do, because that area is low and it acts somewhat as a detention or retention pond at this time, and the water slowly comes out of there. When you build that up, you slope the grade away from the new buildings. As per code, you have to slope away from the building. That water has to go somewhere. Now that area is all built up, plus the hard surfaces of the new buildings, in my opinion, it's going to increase the flow onto my property.
Hard surfaces would by that, do you mean a driveway for any residential development on, I guess, the closest lot to you? Is that what you're talking about?
I call a hard surface anything that doesn't absorb water. A roof, driveway, yes.
Okay, thank you.
Okay, Sean, do you have any comments in relation to the drainage that you'd like to have us consider?
I mean, we took some measurements with a transit, and I'm not sure that I know that on the retained lands, there is maybe a gradual flow of water to a low spot in that area. But, you know, consistent with what the Land Development Committee said and the staff members that, pardon me, I don't think in that particular area, like, I don't think all the water is going to flow or flows down in that direction. I think there's a fall from the furthest lot from Fletcher Road. There's a fall of about 5 feet. There's a culvert that runs under Fletcher Road. And I think it goes from the furthest lot to the culvert under Fletcher Road. I think there's a fall of about 5 feet on the far side of the culvert on Fletcher Road. So I don't think any flow of water would be from the retained lands, not from the proposed development section.
Is there outlet for the covered lots into the roadside ditches that the county or township have? John, do you know if there is outlet to those ditches? It's like if you've taken some grades, is there a fall to those ditches? I haven't been out to look at the ditches, unfortunately. I don't know what's there for them. So are they shallow, or are they capable of supporting the drainage from the land?
I think they're capable of supporting drainage from the land. Like we just measured with a transit, so there's a fall from the far corner down to the Fletcher Road ditch.
Okay, thank you. Any other questions from the committee members?
Well, just a comment. I think Mr. McCleary has made his point known. It's going to be on the record, so it's something that can be monitored. Probably a good thing to have that on there, but I think I'm okay with the drainage situation.
Doug?
I guess I'm relying on the independent assessment made by the county staff that it's not going to change anything. And so the staff being independent of this situation, I would go along with that.
Okay. Yes, Michael.
And I just want to clarify for the benefit of the committee and the parties involved that, that assessment isn't based on any engineering prowess. That's outside of our scope of practice, but just on a planning perspective, overland drainage. So when you always has a right to sheet to the lowest part of the property. And what's happening here is that lands that are at a higher elevation are coming across the neighbor's property and probably to the wetland beyond his property. And so creating the lots in and of itself doesn't create an obligation for the applicant to deal with that overland flow of water. The neighbor doesn't have to accept that overland flow under civil or common law drainage rights. He can stop that from coming onto his property. But if the applicant was proposing to collect or gather that water, then they create an obligation to provide a sufficient outlet. So if they were proposing some kind of ditching or tiling scheme, then they would have to make sure that when they collect that water, they provide a sufficient outlet under common law drainage. So because they're not proposing anything of that nature, the act of developing the properties with the residents isn't really collecting water in a way that requires them to do a sufficient outlet review. We're satisfied that basically the water will go where it has traditionally gone, which is permitted under common law because it's not collected water, it's just surface water drainage.
Okay, thanks, Michael. as a retired engineer that did a number of drainage studies and on projects like this, it's always been my experience most of the times that more money was spent on the study than it would have been to correct the problem. That's why I was asking if there is a reasonable outlet that could be achieved, because if the ditch is deep enough along the road, it's not normally a big deal to get some water drained out to the road in the form of a swale or whatever, and that solves the entire problem. And I'm hesitant to recommend that any kind of drainage study be done, particularly given the position that the staff have made. I just don't think it's worth the effort or the time. So that's my comments on that part of it. Maybe we can move on to the conditions next. I think, Stephen, you had a question or comment on those?
Well, just on the archaeological study, I think it's being brought on because it's in the vicinity of a wetland. That's not an undue hardship and expense because there's a wetland, and I'm worried it's going to be something that's going to be a regular condition. If there's a wetland nearby, we're going to have to do an archaeological study. I don't think it's fair or needed. And if something does come up, what then? You're still going to be able to probably build your house. It's not going to put a stop to it. It's just going to be another expense. So I would suggest, I would make a motion that we take the archaeological study conditions out of all 3 lots.
Okay. Doug, any comments?
I agree with Steve. If there's no glaring need for it, it's an extra expense, and I'm always in favor of making it easier for the applicants, especially expense-wise, on these severance applications. So if Steve's recommending it, I'll go along with that.
Any comments, Cindy or Michael?
I suppose my only comment is, this was an ask of the township. It is in their official plan that if properties within 200 meters of a wetland, marsh, small creek, or spring, that an archaeological study shall normally be required, is the way that the policy works. So there is certainly some discretion in there for the committee to apply some common sense. The archaeological evaluation criteria from the province do talk about that 80 to 90% of archaeological sites are usually found within proximity to water bodies. They do have some other sites that can exclude it if it's been substantially disturbed, since the 1960s through agricultural or other land management practices, which, may apply to part of this property, but not necessarily the wooded area. So, I think the committee's right in terms of applying their discretion, but this was a request by the township. Montague tends to default to their policy to require studies in when it's in their policy, and I think this reflects that.
So did you want to move that motion then, Stephen, that the archaeological requirement would be removed out of the conditions? And Doug, you're prepared to second that?
Yes, I second that.
So we'll deal with that motion first. I'm in favor of that as well, so I'm just going to call a vote. All in favor of removing those conditions? So that's carried. Mr. McCleary, do you have any additional comments that you want to provide us with before we move on to deal with the conditions further?
No, I just thought if there was a way we could come together and put some subsurface drainage along the property line to divert a good percentage of the water to Roger Stevens, I would be on board with looking at that.
Sean, is that something you would be prepared to look at with your neighbor at least? I'm not saying you have to do it, and I'm not saying we make it a condition. I'm just asking if you'd be prepared to meet with your neighbor and discuss some opportunities to try and make things better for everybody.
Yeah, definitely. I want to be a good neighbor. So yeah, if it can come up with a practical solution, I'm happy to work with my neighbors to make life better for them and for me.
I shouldn't say this, but we're taking a lot of money off your plate by not having to do that archaeological study. So I hope you cooperate in this one. Steven.
The question on that is, I'm hearing tile drainage. A ditch along the property line, that's the same thing? Like there's a big difference.
Go ahead.
It's a big difference between if there is a problem, just a backhoe dig a ditch along property line on Sean's side, make sure no water gets over to your side, brings it to the ditch. Is that an option? It's a lot easier.
That's fine with me. But I just thought tile drainage because you just can still use the property.
Yeah.
It's more
Maybe that's
a cleaner look, I guess.
Yeah.
But I don't really care what it is, to be honest with you.
Well, if there is a problem, something then can probably get done.
Great.
Yeah, I'm not recommending that we put a condition in that regard. I'm just wanting to let the neighbors sort it out. What's your thoughts on that, Stephen? Did you want us to put a condition in there or do you just want to allow
No,
it?
I'm thinking that what we have at the bottom of them, recommendations or not a condition. Hmm?
The advisory note?
Advisory notes. Is there any on this one, actually? Yeah, there is. County applicant, yeah. Enbridge has some and the county have some.
Oh, yeah, there are some, but nothing to do with drainage.
No.
Did you want to add an advisory note in there? We normally don't put that in an advisory note, but I don't see why with Cindy. Is there any reason why we couldn't?
No, I think that that's a reasonable request. We can add that in.
Biggest question I got on this is who decides if there's a problem?
Well, I think the neighbor has already indicated there's a problem, so I really just want to see that two parties get together and work towards a solution, and I don't want us to have to mandate that solution or be involved in creating the solution. I just like to see the two parties get together and figure it out. It's, like I said, you normally spend more money in these studies than what it costs to fix the problem. It's very frustrating from an engineering standpoint.
I agree.
Okay, I think we've beat this one to death. So I'm prepared to entertain the motion, and it's moved by Stephen Lewis and second by Doug James that applications B 25-101, 102, and 103 be approved subject to the conditions in the planning report as amended, and the amendment was to remove the archaeological requirement. Any further discussion? All in favor? Okay, that's carried. So you'll be notified. You got 2 years to get things done, as I think that's already listed in the conditions anyway. So good luck, and I hope you and your neighbor come up with a cheap, easy solution. How's that?
Thanks very much to the committee and the staff for helping me through this. Appreciate it.
Thank you very much.
Thank you for attending, Mr. Clary.
There you go.
Are you ready? We'll go ahead with the next one.
Okay, thank you. So the next group of applications is B24, 127, 128, and 129. And this is for the creation of 3 lots in Mississippi Mills for the Bose and Minor Tremblay family. This property is located just north of the town of Carleton Place. The first application, B24, 127, is originally was intended and was submitted to be the split between the east and the west halves in order that they could separate the original township lots in order to take advantage of the severance policy that allows the severances off of the half lot. Because we were processing 2 severances concurrently with that, what we did is assess that first application based on the end result, which is the smaller sized lot once the 2 lots are taken out of that. So originally it was to be 13 hectares, which included the other 2 severed lots. But at the end of the day, once those other 2 lots are created, the size of that first application will be 9.32 hectares. And then the other 2 lots will be approximately 2 hectares in size. All 3 of these lots will front onto Quarry Road, which is a municipal township road. The retained lands will have frontage on the other concession, which is Ramsey Concession 7A. So these applications, the municipality again requested an environmental impact study to be done as a condition of consent. This was as a result of the official plan policies that do require an EIS assessment when anywhere there's development within 120 meters of the significant woodlands and the wetlands. So that is a request, and I believe Mr. Bose wishes to speak to that as well. There was concern and opposition raised by some neighbors due to a boundary dispute relating on the, I guess it would be the south end of the property. There was a court application to confirm a boundary adjustment due to a dispute about where that boundary was. My understanding of that is that it's nearing resolution. They've gone to court, just waiting for the judge's order. The end result won't impact the severance for B27 or B24 127 substantially, in the sense that it would take the lot out of being able to comply with the zoning criteria. So what we did is applied the same standard that we have done in the past, where there has been disputes with properties, and assess the property on the basis of, if that boundary dispute was successful, would the lot still comply with the zoning standards? And in this case, it's relatively minor, and there's no issue in terms of the severed lot being able to meet those zoning requirements. We did check with their legal counsel on that, and that's consistent with what we've done with other applications in the past. Other than that, I think everything else is set out in the report. We did put in a condition regarding the drainage due to the location of a tile drain that looks to impact potentially all of the severed lots in the retained lands. We just want to make sure that that tile drainage doesn't negatively impact the new lots. So the conditions that were set out are slightly different for each of the applications, due to the one being slightly different than the other two. But generally speaking, we are recommending approval of the application subject to the conditions set out in the planning report.
Okay, thanks, Cindy. Just maybe one question from you before we proceed. So if the severance was approved and the order from the judge comes out after, would it apply to the severed lot? Or would there be any title issues associated with the judge's order coming out late? Perhaps you or Doug can answer that for me.
The disputed lands are all contained within the one severed lot for B127. So it's not splitting out into different property ownership where that disputed land is. So I think the only impact would be, there's no impact on the other party being able to correct the title. It's just going to be a different parcel than the lands as a whole. I think depending on the timing, if it's done after they register the severance consent, it would take out some land from the lands that were given the consent. So it would remove the consent status of that lot. So the owners would just need to make sure that that doesn't remerge the lands into the retained lands in that case.
My only concern would be the judge's order may say that it wants to make a lot line adjustment on PIN number, property identification number, or whatever, and now we may have a new one if the severance goes through. I just want to ensure that we don't end up having to force this thing to go to court again because of some little technicality. And if I can be assured that's the case, I have no problem with that.
I don't have the court documents, and I don't know how the judge would set up the order. To be honest with you, I don't know.
Doug, have you got any experience in your previous history as a lawyer with
Yes.
that?
I can't see a problem with the condition, the way it's worded in the proposed conditions. Everything depends on when the survey is done, when the reference plan is done. The reference plan will have to follow the judgment of the court. And so if the judgment of the court realigns that boundary, then the reference plan prepared by the surveyor and probably at the approval of the two lawyers involved after the judgment is issued, that reference plan will accommodate the judgment of the court.
Okay, so there's no danger of it falling through the cracks from what that's the opinion, and I'm happy with that.
As long as-
I like the condition. I think it's a great way of dealing with this issue. I just want to make sure that all bases are covered in that regard, and it sounds like they are.
As long as the reference plan follows the judgment of the court as to where that new boundary line, if it is, as long as the reference plan is prepared that way, then we're covered.
Okay, thank you. So we have at least one gentleman. Do we have more than one person that wishes to, here in person or on Zoom, that wishes to provide some opinions on this application?
Yes, I do.
And your name, please?
Leslie Garrigan.
What's the last name again, Leslie?
Garrigan, G-A-R-A-G-A-N.
Thank you, Leslie. And you are?
I'm a concerned property owner.
Just a second, I got to get you sworn in here. I just want
Oh,
to see
okay.
who all we have to talk, but thank you, Leslie.
Okay.
And you're Greg? Thanks, Greg. And
Is that better?
you believe it on to get an echo, so it's a little bit of a pain, but it works. And yes, Kevin, if you could come up and use the microphone, that would be appreciated.
So I'm Kevin Rintoul. I'm one of the neighbors.
Okay, thank you very much. So I'd ask each one of you to solemnly affirm that the evidence to be given by you in these proceedings shall be the truth, the whole truth, and nothing but the truth. Kevin, I'll start with you.
I do.
Thank you. Greg
I do.
and Leslie.
I do.
Okay, thank you. So I normally let the applicant go first in providing any additional information they want to provide. So Gregory, if you have any additional information you want to give the committee, we'd be happy to hear it. We'll deal with kind of the general application first, and then we'll get into more specifics on the conditions in another round of questions, okay?
Okay, first of all, I'd like to thank the staff for their hard work and the very thorough, diligent report that they prepared on this. Obviously, the big issue appears to be the boundary dispute. And just to put that into perspective for the committee, if you look at the map up there, the bottom right corner of the property is the disputed boundary. So the one that extends from the retained parcel down. Yeah. So it's just the purple on the previous one is just the purple part of it. I think the staff has done a very good job of characterizing this situation. It's a very small part of a 9 or 10 hectare property. If there was a boundary adjustment in favor of the Rintools, it would be 20 or 30 feet. And so it does not affect the fact that these properties qualify for the severances, even if there was an adverse opinion against us. And secondly, if the committee approves these severances, it doesn't in any way diminish the rights of the Rintools. If the court were to rule in their favor, the boundary would be moved over 20 or 30 feet. And again, that's a fairly minor thing. We don't think we should be penalized from this situation by deferring a decision on it until the court makes a decision for the following reasons. This dispute has actually been going on for about 20 years. There are 3 or 4 surveys, our plans, that indicate the boundary is correct in its current position. And my father-in-law, who owned the property prior to us, had an ongoing dispute with the Rintools because the fence on that boundary was removed and moved onto our property approximately 20 or 30 feet. So this went on for 15 or so years. And after my wife and her sister bought the property, or after my father-in-law's passing, we decided to end this, and we started a court action to get an order to get the Rintools off our property. Now, they have chosen to make this about a boundary dispute, a surveying error, and that's fine. That's for the court to rule upon. The court case has been going on for 3 or 4 years. While there may be a decision in the next couple of months, there could be a new survey ordered, there could be appeals, this could go on for years. And so, again, because of this situation, we do not feel we should be penalized by deferring approval. Again, it does not affect the severances and it does not affect the Rintoul's rights to adjust the boundary at a future date should the court rule in their favor.
I guess if I could just jump in here, this committee has nothing to do with making a boundary adjustment. So we have no authorization in that regard, and we're going to do nothing to take sides or to anything in that regard. And I had that discussion with the staff early on to make sure that the rights are protected by both parties through the conditions we proposed, and it seems like they are. So I'm not trying to cut you off, but I don't think we need to go into great details on the boundary dispute.
Okay.
We understand it's there, and we've tried to protect the interests of the parties with the condition that is proposed.
Yeah.
I'll leave it at
Fair
that.
enough. I would just like to conclude by saying that our application is based on existing surveys and our plans. And it is correct as it sits right now, subject to what the courts may do.
Okay, thank you very much. Anything further on the applications, Gregory, or is that it?
I do have a comment on the EIS and the drainage issue, if you want to deal with that now, or?
If I
Okay.
could, just a quick question on the bigger parcel. Okay, so when it is severed or consent's given, that can be sold, right? So hypothetical question, it can be sold. And then the new guy's got this problem. Am I right saying that?
Well, that is correct. We would have to disclose the existence of that dispute, if you will, to any prospective new buyer. We have no plans to sell it, but yes, that's theoretically possible, yes.
Thank you.
It can't be pinned until a new survey, a new reference plan is prepared. It can't be pinned, it can't be transferred until, I believe, until the litigation is resolved. Whether it's with this court decision, is it in Perth? It's obviously in Perth.
Yes, it is.
There is a rule, I think, and I think it's still a rule. I'm talking 15 years ago, that a decision has to be out from the court in a normal situation. It should be out within 6 months of the end of the trial. Have you been 6 months since the hearing?
We are very close, but again, as I said earlier, the ruling could be a new survey and there could be appeals after that. So the issue could go on for a while.
If there are motions, if there are people's principles involved, yes, it could go to appeal. And then you're talking probably maybe even beyond our 2-year period. But if it's with the condition that we have in our conditions, that with that condition, it has to be a final resolution by the court process, and that includes appeals. The appeal will have to come within 30 days of the decision by this court. That's how long you have to appeal it. So you'll know within 30 days whether that original decision by the lower court is going to stand or whether it's going to go to the Ontario Court of Appeal. And certainly there you're talking probably close to the 2 years.
Okay, well, let's move on to the other couple of comments you had. We're going to discuss the conditions in greater detail later, but if you have some comments now, Greg, just go ahead with that when you're got the floor.
Okay, my first one relates to the requirement, or I believe it's a request from Mississippi Mills to have a environmental impact assessment. According to the community official plan, if it affects the significant woodland or wetland, then that is the case. The problem is that they do not define what is significant and what isn't. the fact that they use the word significant means some are and some are not. And as we all know, there are hundreds and hundreds of woodlands and wetlands in the county and in Mississippi Mills. And clearly they are not all significant. Some of them are as small as 1 hectare. The municipality defaults to the ministry, and apparently somebody sits at a computer terminal and draws a circle around every woodlot and every wetland in the municipality and says either they're significant or they're unevaluated. And what that means is that if you go to build anything in Mississippi Mills anyway, you're going to be near something that somebody said was a significant woodland or wetland, and everything requires an EIA. And I think that's kind of ridiculous. I mean, we're talking about 2 residential building lots here, which is the main intention of this severance. And to build a house in Mississippi Mills, you need an EIA. And, you know, I think that's kind of bureaucratic overkill. And if you look at the maps in the presentation, the 2 lots in particular, they're basically fields, and they barely touch on a small 3 or 4 acre woodland at the back. And there is a municipal drainage ditch across the corner of the bigger parcel there, the bottom right corner, which is a municipal drainage ditch, which has become an unevaluated wetland. So again, right next door, you can see Julienne Crescent subdivision. And all of those houses are on private well and septic right beside the wetland and the woodland. So yeah, I just think it's a little over the top if somebody wants to create 2 building lots that you have to do an EIA on them.
Okay, and did you have a question on the tile drainage thing as well?
Well, just a comment, and that is that we've been involved in this property since 1972. And we've had various people farming it over the years. Nobody has ever seen a tile drain or knows anything about a tile drain, and have no idea where the ministry or whoever came up with this idea that there is a tile drain there. Nobody has any knowledge of it or has seen it, including the people that farm the land.
Okay. Well, thank you for your presentation. I'm sure we'll have some questions as we go along. Any questions right now, or will we turn it to the other people that wish to make a presentation? Okay, so I think we'll go to you, Leslie. Would you like to provide any information for the committee to consider prior to making our decision?
Yes, so if you look at the map provided, and I apologize up front, I don't know north, south, east, west. If you look at the map, my property borders the large parcel that Greg is talking about. And I'm in the center. It looks like 700 is written over the line, but 700 actually applies to the right side property, and mine is the center between that box and then the long. Do you understand what I'm saying? Can you hear me?
Yeah, thank you.
Okay.
Yeah.
Okay, do you understand what property I'm talking about?
Do you want me to go point her lot out?
Thank you. Yes, that's perfect. So that's my lot. So just to give you guys a heads up, the property dispute that Greg is referencing is between 738 and 700. My property is not under dispute because Greg deemed it inconsequential, except that my property line follows the property line of 700 and 738. So for some reason, Greg, and I'm not referencing the women because they really have no clue what's happening. It's all Greg, deemed my property inconsequential. So should you give him this, whatever he's doing today, approve his application, you're effectively giving him my land because he's not sued me like he did my brother and sister. He deemed me, my property, inconsequential, and yet he's applying for a severance on land that he has no right to.